Today I will deliver a lecture on land alienation, shifting cultivation and constitutional safeguards. Land is not only a tangible asset but is the mainstay of most of the rural folk as they are dependent on agriculture and allied activities. The tribal economy is also primarily agro-based and they have emotional attachment to land. However, with the opening of the tribal areas, the tribal land is being alienated to the non-tribals. Consequently, a large number of tribal cultivators have been rendered landless laborers. Decrease in the number of cultivators and increase in the landless laborers indicates the disturbing trend of land alienation. Shifting cultivation as the earliest form of agriculture continues to be predominantly practiced by the tribals. Though it has its merits and demerits, it has become a way of life with them. We will discuss about it. The Constitution of India provides certain provisions to protect the interests of the scheduled tribes, which will also be discussed in this unit. First, we will discuss about land alienation. The incidence of land alienation varies from state to state. Laws have been enacted in all the states to deal with the problem of land alienation to the tribals. In the past, an average tribal family had a fair size of land holding, which supported it even with primitive methods of cultivation. The increasing pressure of population on land, particularly from the advanced section of society, has forced the tribals to leave their land. Let us take a look at the historical perspective of the problem. The tribal areas remained outside the land management system for a long time because of their inaccessibility. They developed their own traditional system of land management. The land ownership among the tribals broadly fell under three categories, namely community land, land belonging to clans, and individual holdings. Some of the tribal areas were also covered by the British system of land revenues, and some of them were parts of Indian princely states. These states had no uniform land tenure system. Thus, due to the absence of a regular land settlement system or up-to-date record of land rights, the tribals were at the mercy of the petty revenue officers, forest departments, and the landlords. With the introduction of commercial orientation of land as a resource, there was a substantial increase in the pressure on the tribal land. The problem of land alienation started with the opening of the tribal areas as a result of developmental processes and setting up of various irrigation, power, and industrial and mining projects. The tribals could not take advantage of the legal remedies on account of illiteracy and poverty. In the post-independence period, the reorganization of the states and scheduling of the areas had far-reaching implications on the tribal land. Many predominantly tribal areas, which had remained outside the scheduled areas, did not get the benefit of protective land laws for quite some time. Apart from alienation of tribal land to the non-tribals, its acquisition for various public and private purposes has also been allowed. The incidence of land alienation is more in areas which are rich in mineral and other natural resources and where there are possibilities of increased agricultural production. A sizable area of the tribal land has been alienated. The causes are indebtedness, lacunae in the land laws, acquisition of land for public purposes by the government and other institutions, encroachment and forcible eviction of tribals from their land. The general methods of land alienation have been through sale, mortgage, lease, benami transfers, collusive decrees, fraudulent methods, and land grabbing. Sometimes land has been taken in lieu of the money loaned. Such land transfers have been effected in the form of mortgage, sharecropping, marriage with a tribal woman, in the name of a tribal farm servant, adoption of a non-tribal by a tribal, etc. Apart from alienation of land to private persons, the government has acquired substantial tribal land for various developmental projects such as irrigation, power, industrial, and other projects. Land alienation has been caused either due to inadequate legal provisions or lack of implementation of the existing legal provisions. Some of the inadequacies noticed are: legal provisions are applicable in some states only to scheduled tribes living in scheduled areas or notified areas. There is wide disparity in the application of limitation period. Then, the law of evidence may be suitably amended for the purposes of land alienation to give primacy to oral evidence over the documentary evidence. The term transfer should be comprehensive so as to include illegal and benami transfers of land. No tribal should be allowed to transfer, surrender, or abandon ownership or interest in his immovable property in favor of a non-tribal. The state laws should be reviewed to restrict the judicial intervention at the High Court level. Provisions should be made to deal with cases of occupation of the tribal land through deceit and force. Specific time limits not exceeding 3 months may be fixed for restoration of land to the tribals. It is necessary to have some provisions for regulation of intra-tribal transfer of land. Many states have provided for transfer of tribal land to the non-tribals with the permission of the collector. In case of distressed sale, the government should purchase it and distribute it among landless tribals. The protective provisions have been relaxed in respect of tribal lands mortgaged to scheduled banks and financial institutions. This has been done to extend credit facilities to the tribal landowners for development purposes. Certain administrative and socio-economic measures are also present. The tribal community and its traditional institutions like tribal panchayats exercise an enormous social and moral authority over its members. These should be effectively involved for protection of the tribal interest in land. Survey, settlement, and updating of land records should be completed within a time frame. Special courts with summary procedures should be set up for disposal of land alienation cases. A central model law should be enacted by the Government of India to provide protection to tribal interest in land. The problem of land alienation is closely linked with lack of credit facilities. Protective land laws and easy availability of loan facility through government financial institutions would effectively protect the tribal interests in land. Now we come to shifting cultivation. First, what is shifting cultivation? Shifting cultivation is known by different names. In common English parlance, shifting cultivation is equated to slash and burn method of cultivation. It is also known as jhum by the tribes of Northeast India or Podu in Andhra Pradesh. Shifting cultivation is a type of cultivation practiced in humid areas where forests are cleared fully or partially and the biomass is burnt. Cultivation is taken up for a limited period and then jhum land is left fallow for some period to regain its fertility. Some of the main features of shifting cultivation are: land for shifting cultivation are owned by the community, village, tribe, clan or lineage and allotted according to some set pattern. A large variety of crops are grown in this type of cultivation. It is area extensive and labor intensive. It requires many hands as labor input, and so the cultivators prefer large families. They use very simple tools like axe, digging stick, hoe, etc. Capital investment is minimum and within the means of each household. They keep the plots fallow for many years in the interest of regenerating the forest, which helps in restoring the soil fertility. Division of labor is well defined on the basis of age and sex. It is a very primitive method of cultivation which faces the following problems. It involves the wanton destruction of forests, which leads to severe soil erosion. Moreover, the yield is poor. Shifting cultivation, being labor intensive and land extensive, demands for more manpower. Moreover, there is less scope for providing social amenities to the shifting population. But what are the remedial measures for controlling shifting cultivation? The program for controlling shifting cultivation attempts to provide an alternative source of livelihood to Jhumias, improve their socio-economic condition, and to restore ecological balance in the hill areas. After careful consideration of the reports and recommendations of various committees and commissions, a strategy has been evolved to deal with the problem. The strategy for control of shifting cultivation involves an integrated program of reclamation and development of land for settlement of Jhumias under regular agriculture, animal husbandry, horticulture and forestry. The problems of Jhum control program are threefold: rehabilitation of Jhumia families, development of their economy, provision of advanced technology and capital investment. These programs are all capital intensive. Jhum cultivation is intimately linked to traditional social cultural milieu of the people in various forms. Therefore, any attempt to discontinue it or even curb it would directly interfere with the life, culture and social organization of the people, which have over the centuries survived as instance of adaptation to natural environment. And now, let us go through the constitutional safeguards. The Constitution provides various safeguards in favor of scheduled tribes. These may be broadly divided into two parts, namely protection and development. Protection of interests of scheduled tribes is very essential for their developments. At first, we take a look at the protective provisions. Article 15 prohibits any discrimination on grounds of religion, race, caste, sex, or place of birth. Clause 4 of this article empowers the state to make any special provision for advancement of the scheduled castes and scheduled tribes. Article 16, Clause 4 is another exception to the right of equality of opportunity in the matters of public employment laid down in clauses 1 and 2 of Article 16. While the rights of free movement and residence throughout the territory of India and of acquisition and disposition of property are guaranteed to every citizen, special restrictions may be imposed by the state for the protection of the interests of the members of the scheduled tribes under Article 19, Clause 5. Article 23 prohibits traffic in human beings, beggars, and other similar forms of forced labor. This is significant for the scheduled tribes as many of them are employed as bonded labor. Article 29 provides protection to scheduled tribe communities to preserve their languages, dialects, and cultures. Article 46 provides for promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. Article 164 provides for a minister in charge of tribal welfare in the states of Bihar, Orissa, and Madhya Pradesh. Article 320, Clause 4 provides that public service commissions need not be consulted as respects the manner in which any provision referred to in Clause 4 of Article 16 may be made or as respects the manner in which effect may be given to the provisions of Article 335. Seats shall be reserved in the House of People for scheduled castes and scheduled tribes according to Article 330. Seats shall also be reserved for scheduled castes and the scheduled tribes in the Legislative Assembly of every state according to Article 332. Such reservation shall cease to have effect if it expires a period of 40 years from the commencement of the Constitution, that is, in 1990, according to Article 334. According to Article 335, the claims of members of scheduled castes and the scheduled tribes shall be taken into consideration in the matter of appointment to the services and posts under the Union and the states as far as may be consistent with maintenance of efficiency of administration. There shall be a special officer for the scheduled castes and scheduled tribes to be appointed by the President according to Article 338. The Constitution contains special provisions under Articles 371 Clause A, 371 Clause B, and 371 Clause C with respect to the state of Nagaland, tribal areas of Assam, and the state of Manipur, respectively. The President may at any time and shall, by order, appoint a commission to report on the administration of scheduled areas and the welfare of the scheduled tribes in the states according to Article 339, Clause 1. Article 275, Clause 1, first proviso, envisages provisions for grants in aid for meeting the cost of such schemes of development as may be undertaken by a state with the approval of the Government of India for the purpose of promoting the welfare of the scheduled tribes or raising the level of administration of the scheduled areas therein to that of the administration of the rest of the areas of the state. Article 339, Clause 2 empowers the Union Executive to issue directives to a state as to the drawing up and execution of schemes specified in the directive to be essential for the welfare of the scheduled tribes in the state. While concluding this unit, we can say that due to increasing pressure of population along with alienation of land, the size of land holdings in tribal areas has been reduced in varying degrees from place to place. As a result of this, the number of tribal cultivators has decreased, and there is a rise in the number of agricultural laborers as well as other categories of workers. There is also migration of tribal laborers to other areas due to the depletion of land resources and lack of employment opportunities in their own areas. The integrated perspective of jhum cultivation demands for an improvement in jhum practices in the light of the latest knowledge in the field of agriculture. It would help improve the economy of the people. But at the same time, the associated social fabric and cultural values must not be ignored, so that the people's faith in the same is not shattered. Although the Constitution has made elaborate provisions for safeguarding the interests of scheduled tribes, the enforcement of the same has not been of desired level. Unsatisfactory implementation of the constitutional safeguards is one of the important factors of discontent among the tribals.